Welcome to this free immigration help channel. Today is March 28, 2023 and we are getting into the volume 44 of me going through your comments and questions and answering them. So let's start with the very first one from Roberto Falhaber, and I'm very sorry if I'm mispronouncing the names. Well, I've got a case here that I would really appreciate some help and insight into the situation. I'm from Brazil, traveling using a B2 visa. I arrived here in the United States on March 17th with my flight back to Brazil being on June 5th. Okay, my intention was to stay 80 days because my sister is studying in New York on an English course. She arrived before me and my father would arrive on the last of those 80 days so we could make a visit to New Orleans. The thing is, the immigration of Miami, the CBP thing, that's the name, seemed to be not that sure about my stay in the US. In the end, they gave me until April 17th to stay in US with a limited stay. My question is this reversible or can be contested? My father is the sponsor of my trip. I already have my return ticket to Brazil. I've already been in US many times, but this is the first time that this happens. Any advice on how to proceed and if it's useful or not? Sorry for this big test, but needed to make it the most clear possible. Thank you. Thank you for the question, Roberto. I'm pretty sure I have already received this comment from you and I've responded it in my previous. I don't remember which volume was, so I'm gonna answer again and I'm gonna post the response to this so you don't have to search for the previous video, but I'm pretty sure I already answered. Basically, there is absolutely no point trying to fight with the CBP. It's pointless. It's gonna take more time and most likely you're not going to be able to prove anything because at the end of the day it's really at the discretion of the CBP whenever it comes to the duration of stay. So the best thing that you can do, because it's pretty recent, you just came on March 17th, so you still have some time, is to file as soon as possible the extension of stay, which is the form I-539. Let me show you where to find it. This is the official USCIS government website. So we're gonna go to forms, all forms, and then 539. Here we go. Here we go. Application to extend, change non-immigrant status, and you can file it online. So it is pretty quick, and I would do that. I would recommend doing that as soon as possible. Why? Because this does take some time to process. There is a risk that it might not be processed. It might not be approved by the time that you actually have to leave. All right, so two things that you need to figure out right now is to file that extension of stay, and then also to, if there is a way for you to cancel your return ticket for now that you have, few months down the road, and just, so that just in case if the petition for the extension of stay is not approved, so that you don't have to wait here because it is risky. You don't want to be in a situation where you are in the country and you're waiting for the petition to change your status, extend your duration of status, to be denied just for whatever reason. And most of the times they're approved, and in your situation it seems pretty straightforward, so really it should be approved. There shouldn't be any problems with it. But just in case, to be on the safe side, I would work with the airlines and have the ticket canceled for now, for the older date that you have, or at least if there is, figure out if there is ability to change the date of return on the airline ticket. That would be the best thing to do. I wouldn't, you can submit an inquiry with the CBP, but again, don't expect much from them because again, it's at their discretion whenever it comes to the duration of stay, which honestly was completely unfair in your case. I don't know why they did it to you. It's really silly. It really makes no sense. Plus they should have seen the return ticket. So it's really unfair. But again, fighting against them is gonna take time, it's gonna take money, and at the end of it, you're not gonna prove much, unfortunately. All right, let's move on to the next comment from Fee and Keba. Team Saho. How do we know how long it takes for US citizen married to spouse? Okay, so the question was asked on the visa bulletin for April 2023 video that I made. So whenever it comes to US citizens petitioning for spouse, you don't have, and it's a good news for you because you don't have to deal with the visa bulletin at all. Because whenever it comes to US citizen petitioning for spouse, there is no immigrant visa cap on that particular category. So the only things that you are dealing with whenever it comes to the weight is approval from USCIS, and then documentary review and get documentarily qualified with the NVC. So with USCIS, I can show it to you right now. Again, use the opportunity. This is official government website for USCIS. So we're gonna go to tools and we're gonna go case status online. And last time I did that, for whatever reason, I guess they were doing maintenance. So USCIS processing times information, visit page, there we go, it's working now. So we're gonna select petition I-130 for alien relative, and it's going to be US citizen filing for spouse, parent or child under 21. All these categories, they have no immigrant visa cap. So depending on which field office that you're in, let's do California for this example, and then you can check it on your own. About 15 months. So you will still be waiting. You will still be waiting, I would say about a year, maybe year and a half for the approval from USCIS. Then once USCIS approves your petition, they transfer it to the NVC for further processing. Once the NVC receives all your payments, all your affidavit of support, visa application, all your financial documents, tax returns, tax transcripts, once they're satisfied with all of that, they will documentarily qualify you. Once they do that, they will transfer the case to the local US embassy for your spouse to go to that final interview and obviously do the medical examination right before the interview, and then go to the interview, get the visa, and then come here. So for all of this, you're probably looking at about a year and a half, maybe possibly 2 years if there is a little bit of a back and forth with NVC. But again, good news for you, you don't have to deal with the visa bulletin at all because there are no immigrant visa caps on this particular category. All right, let's move on to the next question from Navadine Miller. Do I still need to send any payment with the application? Okay, so this question was posted on the I-912 video that I did, request for a fee waiver, and that's excellent question, Navadine. Thank you very much for asking it, because this will probably clarify for a lot of people. So yes, you do want to send the payment with the application along with this request for a fee waiver. And the reason why you want to do that is because just in case your fee waiver is denied, and unfortunately a lot of times it is unfortunately, if we're being completely honest, most of the times the request for a fee waiver is denied, even if it seems like great reasons to you why you should be approved for a fee waiver. A lot of times USCIS, for them, it's not good enough of a reason, so they deny. Most of them, they get denied. So just in case if it is denied, you have the payment already there, so USCIS, they won't have to actually reject your application and send it back to you saying that, hey, we didn't get the payment with your application. All right, so you don't want to waste time, and it is in most of the scenarios, in most of the cases, it's much better to end up paying the fee but not waste a lot of time of this back and forth where you're sending them the application, they review it, they see that there is no payment, they deny your fee waiver, they send it back to you. You definitely don't want to deal with that. So yes, you definitely want to submit the payment together with the application, together with the fee waiver, obviously submitting the reasons why you think you qualify for the fee waiver, and then just hope that it is approved. But the worst case scenario, if it's not approved, you already sent the payment and they will accept the application, obviously with the payment. They'll charge you for that. All right, let's move on to the next question from Leah. Mother applying for widowed daughter, does it fall under unmarried son daughter above 21 years of age? Okay, so that was question on so it's petition I-130. Yes, excellent question, Leah. Yes, correct. So if whatever it is, widowed, divorced, as long as they're not married right now, that's it. That's going to be in the unmarried category, son's daughter over 21, if they're over 21. So I'm gonna post this. Very short answer. Moving on to Eric Romero. Do you know why my status would change a week ago? It said 4 weeks and now it says 4 months. Eric, actually, you're not the first one who mentions it. it almost feels like USCIS went through all their dates and they have updated a lot of these categories, a lot of these petitions and applications, the processing time for these petitions and applications, because you're not the first one I'm getting this comment and this question about, you know, somebody's application was showing much less than it is showing now as compared to in a couple of days. So what I'm gonna do is, let's take a look, because for I-130 petition, it looks exactly the same. Now you put it on the general video that I've made for USCIS case, taking a long time. So let's take a look. I-130 is taking about the same. Let's take a look at, for example, application to replace permanent resident card. I'm gonna see, because I remember initial it was about, let's see, 20 months it's showing, and I think it was originally 21, so this didn't change. Let's see what else I'm familiar with the processing time specifically. Let's see refugee asylum relative petition, if this one changed, because I'm not sure which category, but no, this one is showing the same. So Eric, if I can, I'm gonna ask you to please follow up. If you can follow up with a comment and submit a separate comment. Don't respond to this comment here, because I'm not gonna see it for whatever reason. YouTube doesn't send me notifications for responses. So if you can submit a separate comment, and please let me know which application specifically you are referring to, and then I can take a little bit of better look and see what's going on. But like I said, you're not the first one. I did get a few comments, I did a few mentions that their times changed and became much longer compared to what they were just a few days ago. Again, I don't know which application it was specifically to, so if you can let me know, it would be better. But I'm assuming, I am thinking for now, USCIS might have updated their processing times for some applications that they're experiencing delay on. But again, if you could let me know, that would be very, very helpful. All right, let's move on to the next comment question from Carlos Mangasep. I'm sorry if I'm mispronouncing. My daughter petitioned me. She is a US citizen and my priority date is on March 4th, 2020. And the last communication through email dated Saturday, January 14, 2023 at 12:15 a.m. It says NVC will work with US Embassy. Oh, great. To schedule an interview appointment for you. Great, congratulations, that's good news. Once we have confirmed an interview date, we will send a notice to you, your petitioner, attorney, if applicable. Is it possible to know when will be the approximate interview date? Okay, Carlos, so congratulations, that's really good news. Now, they sent you this email on January 14th. Usually it does take, you know, it can take anywhere, I've seen it take anywhere between 1 month. Usually that's where they try to do it, schedule it within 30 days. 30 days in advance, but I've seen this take as long as 4 months. So I would say any time between now and probably another month, if you just, you know, patience, a little bit of patience, probably even less than a month, you should have your interview scheduled. Now it's in Manila, it's in Philippines. Okay, so I know that Philippines, they do have, because they have a separate chargeability category. If you look at the visa bulletin, you'll see the Philippines, they have their own chargeability category, which means that they have heavier immigration numbers. So I would assume that the embassy that is in Philippines is busier than a lot of other US embassies around the world. So this might be the reason why you're experiencing a little bit longer time to get the interview scheduled, is because they have just more people basically waiting in line for these interviews to be scheduled. So I wouldn't worry about that. I just a little bit more patience. Just be prepared. What I would do is I would do some research on surgeons, not the surgeons, but the what are they called? Surgeons, physicians, surgeons. Basically, USCIS, they have their own medical examiners, right, that work with the US Embassy in other countries. They're approved physicians, right? So I would recommend finding one, just locating one, just keeping it in mind where he is, where the office is. So once you are scheduled the interview, you can schedule the appointment there and then go and do your medical examination. That's really the only thing that you need to be concerned about. And then of course the interview itself, if you have all your documents already prepared, the tax transcripts are now required instead of the tax returns. So ask your daughter, she needs to send you the tax transcripts. Obviously, all the documents that have been submitted to the NVC, you will have to have them. I've seen in some cases the original birth certificate of a child who's petitioning for their parents has to be presented during the interview of the parent, which means the petitioner, the child, son or daughter, in your case the daughter, she will have to send her original birth certificate to you so that you can go with it to your US embassy. Now, it's not in all of the cases, but in some cases I've seen that. So you can do stuff like this, prepare, but the only other thing is just, you know, patience, waiting for the interview to be scheduled, but it should be scheduled anytime now, because it's been already a couple months, so really anytime now. All right, let's move on to the next question comment from Precious Ebiwa Okoli. Definitely mispronounced it, I'm very sorry. My husband, a permanent resident in the US, filed Form I-130 for myself and our daughter, which has taken longer than expected. Yes, unfortunately, these petitions are on the delay, as we can see from the visa bulletin, even though they are not even related to the visa bulletin, but we can still see the backlog for them. And we have called and inquired about our case and got a response saying it's in line to be reviewed by an officer and to allow for an additional time. Unfortunately, yes. Most of the times you'll get a boilerplate response. The question is, I'm currently pregnant and with this unexpected delay, should I give birth in my country here and will later get an approval and subsequently go ahead to migrate to the US? What happens to my baby? Do I have to start afresh and file again for the child? Unfortunately, yes. And I know it's a really dumb system but I actually worked with a few cases exactly like this. One was a petition I-130 and one case was a DV lottery, and in both of the cases, while the process was still being reviewed, while the family was going through this interview process, they had another baby. And actually in the DV lottery, they completely denied the whole family because it's dumb. Unfortunately, it is dumb, but that's how it is. That's what you have to prepare. So if your baby is born in your home country, obviously the baby will have the citizenship of that home country, and that means that you will have to do another petition. In your case, it's a little bit better than the DV lottery, just because you have more control over your case. But if that's the case, that yes, you have to be prepared, unfortunately, because the system is just it's too much bureaucracy. That's what it is. It really is too much dumb bureaucracy. That's really what it is. All right, let's move on to the next question comment from Amy Cortez. Hi sir, do you have an idea when can I get my scheduled interview F4 category from Philippines? Documentarily qualified April 2022. Priority date January 2003. Thanks in advance. You're very welcome, Amy. Let's take a look at the visa bulletin. Like I said, the Philippines, they do have their own chargeability area. So we are looking at this very last column right here for the Philippines specifically. So let's start with the dates for filing, which would be the priority date. And in your case, you said F4 category. Priority date is January 2003. So as you can see right now, they are already getting to applications from, well, not getting to the applications, but they are issuing the visa. The immigrant visa is being issued to the applications with the priority date in April 2004, and you are in January 2003. So let's take a look at the documentarily qualified date now. You said you are April 2022, and for documentarily qualified, we don't really have a good updated information here. It still shows August. So they documentarily qualified you. They actually waited for the immigrant visa closer to the availability of the immigrant visa to documentarily qualify you. That's why it kind of does not match anywhere close to the documentarily qualified dates here on this graph right here. I'm assuming these back when they were receiving the applications back in 2002, they were documentarily qualifying them pretty much as soon as the application got approved by USCIS. That's why you see a huge difference between two dates. So we are actually going to stick to the priority date, and that will probably make a little bit better sense. Plus, you know that you're already documentarily qualified, so the immigrant visa should already be available anytime now. So if you're documentarily qualified, I would say very, very soon you should have your interview scheduled, and the immigrant visa should be available anytime now, because as you can see, they are issuing the visas are becoming available for those people with priority dates back in April 2004. So two things I'm thinking: either you had somewhere on the way on the application process, maybe back and forth with USCIS or with NDC, that caused a little bit of delay, and obviously the whole pandemic situation that we had, it caused quite a lot of delay. So for the past year and a half, if you look at the visa bulletin, the things were not moving along at all. So that's why I think you are still experiencing a little bit delay, and it kind of a little bit is mismatch, about a year of a mismatch actually, with the visa bulletin graphs that we see here for Philippines. So can't say really much, unfortunately. Just wishing you a little bit more patience, but really hopefully anytime now. Should be really soon, because now finally the things are starting to get, you know, finally moving along after they have been on really a complete stop for a very long time because of the pandemic, because of the whole situation. So hopefully soon. All right, let's move on to the next comment from Renato Fernandez. My brother petitioned me for F4 category and was approved December 3rd, 2003. How many years I have going to wait for my visa? Okay, Renato. So again, this is very similar to comment to Amy. Again, F4 category. Again, your priority date is in 2003. So let's see. I don't know your chargeability area, but looks like you might be. Well, let's see. So we got 2003 here for F4. Everything else. So you're either Mexico or Philippines, and I'm assuming, since Renato Fernandez, well, again, it might be both Philippines and Mexico. So if your chargeability area is Philippines, then anytime now, again, just like Amy, anytime now you should be getting your interview scheduled for the U.S. Embassy for the immigrant visa. But if you're Mexico chargeability area, then you are probably roughly looking at about 2 more years, because as you can see right now for Mexico chargeability area, the immigrant visas are becoming available for those people that have the priority dates from April 2001, which is about 2 years behind your priority date. So if you want, you can let me know your chargeability area, and I might be able to give you a little bit more details. But again, visa bulletin, you're looking at it, there's only 2 chargeability areas that make sense with your priority date. It's either Mexico or Philippines. And with Philippines, if you're from Philippines, anytime now. Mexico, you're looking roughly at another 2 years. But again, it's a very rough estimate, because things, you know, as like a year now, like I said, visa bulletin, they only been getting worse. The date's been getting worse. They haven't been moving along, and the reason for that is because of the whole artificial backlog that was created during the pandemic, unfortunately. All right, let's move on to the next question comment from Oswin DSA. I'm on LPR, legal permanent residence, and if I have to concurrently file for spouse, should I use date of filing or final action date? Okay, great question, Osman. So whenever it comes to just initially filing, right? Whenever it comes to just initially filing the petition, if you want to kind of estimate the processing time, you don't deal with the final action dates at all, because the very first thing, once the USCIS accepts your petition, it's the priority date, it's the date of filing. All right. So you would be looking at the dates of filing, which is the graph B. However, here's the thing though, because you are legal permanent resident and you're filing for your spouse, there are no visa caps on the immigrant visas for the spouses of legal permanent residents. So the reason I think why you're asking this question is because you're looking at these two graphs and you look for the F2, you're looking at F2A because that's where your spouse is going to be. F2A is spouses and children of permanent residents, children under 21 unmarried, keep that in mind. And if you look at the final action dates for F2A, there is some time that you have to wait, and then for the dates of filing there is no time. So the reason why there's two differences between the two dates, actually that's the same cases. It's just this is the priority date, this is the documentarily qualified date. The reason why I think they just did not improve, they did not update this particular one yet. In fact, this one right here, this category was just updated with April. If you look at the March 2023, they are still showing current. So it's the same case with this. I'm hoping that by the time, if you're filing the your petition just now, I'm hoping that by the time it gets to, it gets approved by USCIS and then transferred to the NVC, I hope by that time they're gonna catch up with the processing, and because there is no cap on these visas. So once your petition is documentarily qualified with NVC, the immigrant visa is already available. So really NVC, all they need to do is just transfer your case to US Embassy, and that's it. That's really it. The only reason why there is such a huge delay is because there was, again, that artificial backlog. Not the backlog that we have because of the visa cap, the availability on the immigrant visas for a lot of other categories that are limited, but because they had a complete stoppage with the processing during those year and a half of this whole pandemic situation. So I hope I was able to answer your question. If anyone, if after, if something is not clear, do not hesitate to follow up with more information, with more questions. It's as many questions as you have, welcome on this channel. Just make sure to submit it as a separate comment. Do not respond to my comment, because if you do, I'm not gonna see it. YouTube does not send me those notifications for whatever reason. All right, let's move on to the next question from Red Purple Scarlet. Hi, thanks for your video. You're very welcome. Thank you for watching. I'm filing for myself and my 10-year-old child. Do I have to send the payments differently or in one check and put the details on the check? Thanks again. Okay, great question, Red Purple Scarlet. So this question was asked on I-131 application for travel document. So I don't know the answer to this question, but USCIS, official government source, does. So let's take a look. I'll use this as a opportunity to show you navigation and how to find your own answers quickly on official government source. So we're gonna click on forms and we're gonna go to all forms, 131, search, and that's gonna be application for travel document. Here we go. So let's take a look. Let's see, authorization documents protected. Okay, that's not for us. To improve efficiency, reduce, that's not for us. Core decisions, that's not for us. So we're gonna go straight into the application itself. We're gonna click on it. And let's see, information about you, application type. Okay. Country of birth, physical address, processing information, information about your proposed travel, complete only if you're applying for re-entry permit, complete only if you're applying for refugee travel document, complete only for advanced parole, and then the signature. Okay, so from this application, as you can see, this application is specifically for one person. There is no place on this application where you can add additional travelers that are with you, add your spouse, add your children, right? And as you can see, there is not even a supplemental page for this application at all. So that means that you do have to submit a separate application for yourself and a separate application for your child, which honestly is silly and it's a bureaucracy. I understand. I mean, your child is 10 years old. Separate application for a 10-year-old is quite ridiculous, but unfortunately, it's, you're dealing with the system, and that's, you're entering the rules of the system, so you have to play by the rules, all right, if you want to play this this game. So yes, you do have to submit a separate application for yourself and a separate application for your child. And when you're submitting two separate applications, you always have to submit two separate checks, two separate payments for the separate applications. Why? Because if you do send one check You either have to send it with this application package or this application package, and you can't submit them both together. I would recommend sending them separately. You can probably send them in one envelope as as a mail, but still you're gonna have two separate application packages in one envelope going to USCIS. Unfortunately, at this very moment, as you can see, there is no way to file this online, this form. I really hope that I think this is one of the forms that just has to be available to file online. So I hope USCIS does make it available online sometime soon, but as of right now, you have to file it by mail. So two separate application packages, even though it's in one envelope. You can send it all together, but it's going to be two separate applications, two separate payments. Alrighty, we're now at the 30-minute mark, so I'm going to address the rest of the questions that I have, and I do have quite a lot of questions that I need to catch up, so I'll probably make another one of these videos either today or tomorrow for sure, to try to catch up with all your questions. If you have any follow-up questions, please do not hesitate to ask them. We'll be happy to address them. As always, thank you very much for watching. God bless. I'll see you in the next video.